what you call it as the concept of right to privacy. Terrorism, insurgency and fundamentalism, I think the minister was right in the morning and very beautifully said that we are not talking about digital divide, but the divide in the society. Right? We have all types of divisions, and I think these things will continue. And to what extent the privacy rights will be violated by them is what we should guess, and then I will leave it to you. There is also, at the hindsight, when you look at it, there is drastic violation of human rights at times. I think the lawmakers, over a period of time, they moved forward to trust the police. The first thing that we should now understand is, you should trust them. But at what level? I think if you look at POTA, the Prevention of Terrorism Act, very clearly said a confession can be given to a police officer. As against what was there earlier, no confession is permitted, they have authorized a superintendent of police and above, they can give a confession, but he has to follow certain rules, that he must tell the accused that he is under no obligation to give the confession, and he is recording that confession in the digital form or whatever form, and only when he is willing or she is willing, then record it. And with all these things, when they are presented, the lawyers argue any evidence given to police is wrong, is invalid, and the courts also at times they don't look into the statutory support they get, they also reject the cases. Now, how are you going to identify these things? How are you going to? I think one mobile phone which they confiscated from the accused, they were able to identify different people, they called all of them. This is the method through which, because beyond reasonable doubt you have to prove. How are you going to prove when their hands are tied? I'm not here to canvass for the rights of the police, but I'm only saying that they are parallelly made important, and it's very difficult in an era where information technology is changing very fast. I'll just take a couple of minutes. This also should be kept in mind. India also joined the other countries, and provided some sort of legal response to limit the privacy rights. POTA is one, I think. The second one is the IT Act of 2000 and the pending Amendment Bill of 2006. I will not get into the details of that. Right to Information Act. I think, if one carefully looks at Section 8, 1J, very clearly provides and protects the personal information of the individuals, and that need not be shared with anybody else. A public authority having personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the CPIO or the other authorities, as the case may be, is satisfied that a larger public interest justifies the disclosure of such information. Similarly, there is a provision, Section 8(1)(e), which is also another exemption clause. Info available to a person in his fiduciary relationship need not be shared, and I will not get into the details of the others. Personal data protection bill, I think something is being discussed. I will not. Just to conclude, keeping all these developments in mind, developments taking place not only in India but in other countries as well, we have to look at case-by-case development of this right to privacy before it is concretized and presented in one form called as personal data protection or whatever it is. This is one I think we should keep in mind. We should also review, when I looked at a quick review of this personal data protection bill, it is very, very narrow area which they have looked at. I think there is a need to look at the review, the existing laws, and bring the conflict between the right to privacy and the national security in a holistic manner, and adopt this bill accordingly so that it is further strengthened. Very easy suggestion I can give: find a balance between right to privacy and right of others. Very easy for me to say, but where do you strike the balance is what we have to continue to discuss. The next suggestion I would like to give is think in terms of appointing a privacy ombudsman. Now, many people mistake ombudsman for enforcement. Ombudsman is not for enforcement. Ombudsman will quietly look at all these developments and finally evolve what you call it as the best practices. And those best practices principles will be adopted and followed by the industry or by the government or by anybody else over a period of time. It's a continuous process. So his job will be limited only, not to interfere, not to decide. He is not going to decide anything. But if there is a complaint, he will look at all those things and evolve what you call as the best practices. And I think we should not mistake, because the moment it goes to the government, they say ombudsman. They have a different understanding of ombudsman. But I am suggesting for an ombudsman who is not going to decide any dispute, but who will observe all these intricacies. And constantly, in Scandinavian countries, when the ombudsman releases the report, every department with great interest, but take a copy, read everything, and within 2-3 days they incorporate all the suggestions given by them, because he has applied his mind and brought in what you call as the best practices to reduce the tension within the civil society. There are various other aspects I will not get into. Let me just conclude by 2 observations which I thought very interesting. The protection of personal privacy. By the Vice President Hubert Humphrey, observed almost about 40 years ago. We act differently if we believe we are being observed. We act differently if we believe we are being observed. If we can never be sure whether or not we are being watched and listened to, all our actions will be altered and our character will change. I think the human nature, because if I am being observed, my behavior is something. If I am not observed, my behavior is something. And where is that limit for this right to privacy? Right? The second observation I would like to quote is from Senator Sam Erwin, who in 1974 wrote, "Each time we give up a bit of info about ourselves to the government, we give up some of our freedom. For more the government or any institution knows about us, the more power it has over us. When the government knows all of our secrets, we stand naked before official power." So that is the other extreme. So the reality, the object of the seminar of this nature is to debate the meaning, the nature, the scope of right to privacy, and balance it well with what you call the limitations. And I think this conference will take us forward to look at all these things and think in terms of having a sort of consensus so that the civil society in this country will have some meaning. Thank you very much.
Thank you, Dr. Vijay Kumar, for that erudite presentation with the background of how the law has evolved in UK, USA, and Canada, and how the right to privacy was confined to property and then was extended to the person, and how the constitutional framers did not include the right to privacy first, but later decisions have specified that it's part of the fundamental right under Article 21, and also for having emphasized that there should be a proper balance between the right to privacy of an individual and the rights of the society, and above all the security of the state. Thank you very much for pointing that out, and we'll take into account all these suggestions into consideration, and also that privacy ombudsman suggestion, that's worth considering. Now may call upon Mr. K. Sudhir, advocate, to give his presentation on the Personal Data Protection Bill 2007.